Our next speaker spent 20-something years as a paralegal. I'm not going to say how many, but a good amount of time. This was both did plaintiff's work and defense work in the civil arena. And she noted that there was a real need to be able to track what settlements and verdicts were going on. Does anybody ever here use the company CaseMetrix? Okay, some. Knowing what similar cases have resolved for, either verdicts or settlements, can be very helpful, just as Jessica spoke about in mediation. It can be helpful with adjusters as well. So our next speaker decided, I'm done with being a paralegal, I'm going to go start a company. So she founded CaseMetrix. I do have a fun fact about our next speaker too. In high school, she was the only girl to be both a cheerleader and on the debate team. Please welcome Kim White.
Thank you. Okay, it was 27 years that I toiled away as a paralegal before starting CaseMetrix 10 years ago. So I've been in this business 37 years at this point. Being a paralegal and working on both sides, initially the first half was in defense work and the last half was in plaintiff's work, gave me a unique perspective. And I know that every case is different and every firm is different. There's a lot of variables in deciding what cases are worth. But I started to see this huge disparity, so I partnered with a database expert and we came up with CaseMetrix. We built it all over Georgia and all 159 counties. And over the last 10 years, we've spread it throughout the southeastern United States. And I think that's why Houston asked me to talk to you about using prior settlements and verdicts to maximize good settlements, because 95% of the time, that's what's happening. The data tells us 95% of the time cases are settling. So everything I'm sharing with you today is really based on feedback that I've gotten from attorneys, both plaintiff and defense attorneys over the past 10 years, schooling me on responsible ways to use that data. Plaintiff's attorneys too often were calling me at 4:30 at the end of the day at mediation going, hey, Kim, I need some broken leg cases. The other side's packing up and leaving. They're going to go, hurry, get that to me. And so what we tried to do is educate them about getting some data gathered early in the process. I think instead of looking at it at the end, when plaintiff's attorneys are trying to decide whether to even take a case, based on what you know at that point, I think that's a good time to first look at the data. In doing that, you are making an informed decision about how much time and money you can justify investing in that case. It's kind of a bad feeling to go, 2 or 3 years down the road and you look at it and you see what the expenses are versus what the case value is. That's kind of doing it backwards. And I know that sometimes in representing plaintiffs, some of the plaintiffs I represented had some, we'll call it selective amnesia. And so when the facts change, you can rerun it and get them more on point. Defense attorneys, one of the least attractive parts of doing that job is writing what I call the crystal ball reports, and that is every 30, 60, 90 days, the insurance companies are requiring you to evaluate that case on any number of levels. And one of the things they want you to do, often too prematurely, is to tell them, based on what you know about the case, maybe you're not even finished answering discovery yet, is what you think a jury's going to do with that case if it is tried 3 or 4 years from now. Often when I would get a case from an insurance company, they had, I felt, sort of prematurely set reserves on the case, and then we would start discovery, start finding out different things, and what you've got to do is help them reset the reserves, put more money on it. What you're really doing, well, you're telling them that you're looking out for their interests. What you're really doing is making sure that they're giving you adequate authority to get cases that shouldn't be tried for any number of reasons. And so often what you can do is show them some of the big multi-million-dollar verdicts in similar cases when you're only asking them for another $100,000 in authority. Plaintiffs' attorneys often use settlement and verdict data when they receive offers they don't want to take. Have any plaintiffs' lawyers in the room ever received an offer you didn't want to accept? Yeah, every day, right? So, but what if your client has stopped treating? and you've got a really crappy offer from an insurance company, and your client stopped treating, you don't have any new medical records, you don't have new medical bills, you don't have one single thing that you can forward to the carrier to try to get that number up. You need to appreciate what's happening on the other end with the adjuster or the claims manager. A lot of these people live and die by their audits. They have to properly document files. And these people are severely overworked. Their caseloads are enormous. So they have to document everything to show why they put more authority on it. No adjuster is going to walk down the hall to their claims manager and ask for additional authority on the case without being ready to say why. That's why you've got to give them something. I've actually had conversations with adjusters before saying, what do you need from me? What would help you get more authority on this case to pay us more? Cases that are sitting on the shelf and they're not performing are not only not making you money, they are losing you money. So this goes directly to your paycheck. It goes to running your business. So I think it's a really good idea to take non-performing cases off the shelf, put some data on them. If you don't have a new record or bill or anything like that, put some recent verdict data. That gets it back on the front burner with the adjuster. Hey, did you see this verdict that came in last week for 60 grand? I'm only asking you for 8,000. And this was a verdict against your carrier. That might be the thing that gets it back on the front burner. I think time-limited demands are very scary to defense attorneys. They should be. Sometimes I think plaintiffs' lawyers might use them a little more than they should, but they do get the attention, or they should get the attention of the insurance company or the insurance defense attorney, because you know you can be on the hook ultimately for a verdict that's greater than the available limits of liability, and then those limits don't matter. You're also looking at attorney's fees, cost, interest, and that can end up being a really big number. One of my Florida clients had a case. They made a $10,000 limits demand. Sadly, in Florida, minimum limits are 10 grand. Geico could have gotten out for 10 grand. But they didn't. Ultimately, that case resulted in an $8 million verdict, plus all of those add-ons. So a very different story. But of course, not every case is a limits case. And so just because somebody's sending a Holt demand, it doesn't mean it's really going to hold water. So if you see similar cases with a lot of defense verdicts, you might send that back with your sorry, not going to happen letter. Managing a client's expectations, I think, is a really good use of data, whether you're representing plaintiffs or defendants. Every plaintiff I've ever represented has asked me 3 questions, and you probably know what they are. How much am I going to get? How quickly am I going to get it? And what's an update? It's like having a kid in the back seat of the station wagon when you're going to the beach and they're like, are we there yet? Are we there yet? I've had plaintiffs that I've had to babysit that way because I've worked for very busy attorneys as a paralegal, and I had to babysit those clients. And often you don't have anything new to tell them. And we've all had those soft tissue plaintiffs that will call you 2 or 3 times a week. They think they're going to get that money, they're going to retire and move to Hawaii. They don't understand because, think about it, their perspectives are skewed. And instead of being irritated by that, I think we need to respect that. We need to understand where they're coming from. They're not in the same line of work that we're in. So what are they doing? They're driving down the street and they're seeing billboards with 7-figure awards on it. They're seeing that sort of thing on the front page of the paper. Everybody's got a neighbor or a cousin or somebody like that who got more, and they're not understanding the differences in their case and other cases. So I think that's a good opportunity to show them cases that are directly on point, to say, this is how your case is different. And it's also a good opportunity to talk about problem areas in cases, because they do exist. Remind them that some people get nothing. I've seen lawyers in mediations that will sit down with plaintiffs and they'll say, okay, here are 100 cases directly on point to yours. It's a back soft tissue case as a primary injury in Fulton County, Georgia, with less than 500 in meds, less than 5,000 in meds. It's a rear end, slight property damage case. These happen all day, every day. It's the #1 accident. Here's 100 cases just like yours. Here's the offer that you have. Of this 100, there's only 4 people who have done better than you. One was the teacher of the year, okay? And show them cases that aren't exactly the same sometimes too, because you want to show them, now you had a problem, you've got contrib in your case, there's questionable liability, and explain to them what that means. Talk to them about apportionment. Don't have that conversation with them about apportionment and how they can zero out when you're sitting there waiting for a jury to come back when you're trying a case. Do that early on and prepare them for it. You know, if a jury decides that they are 51% at fault and there's a $5 million verdict, they need to know they get nothing. Don't surprise them with that at the end. I think it's really good to set that stage. Defense attorneys are also trying to manage their clients' expectations over at the insurance companies. Insurance companies, I think the better you do, the higher their expectations are for you. I know at my firm, when I was in defense, we had 3 defense verdicts in a row for a carrier, and we were superheroes for about 1 minute. You know, and then they expect you to do that every time. Well, you can't every time, because some of these cases are absolute dogs, but because you've gone and won a lot of them, they want you to try everything, and it really threatens the amount of settlement authority you're able to secure. And that's why it's important to share those higher numbers with the carrier to justify increasing reserves and getting a little more money. Then if you settle within the increased authority, you still get to be a superhero. Just because you get all that extra money doesn't mean you have to spend it. Again, it's all in how you frame it, like everything else. I think determining whether a top dollar offer is a reasonable number is another way to use the data. We've been tracking everything. My business partner is a statistician, and he wanted to look at before and after offers when people use settlement and verdict data, such that it's quantifiable. This was the offer. I gave them some settlement and verdict data, and then the next offer was higher or stayed the same. So we've been tracking it every year. In 2018, it was 93% of the time. So data is power, and data is money. Data can make you money, data can lose you money, you know, so you can't ignore what's happening there. Another way to use this data is when you're trying to maximize egregious citations. You know, in a perfect world, you're going to get a case once in a lifetime maybe where you've got a DUI defendant, it's a trucking company, they've got 100 million limits, there's a DUI, it's clear liability, you know, the defendant's insured is an absolute jerk, the stars are perfectly aligned from a plaintiff's attorney's perspective. And so you want to plug in all of those variables and do all that, but sometimes data can be a little bit counterintuitive. Lawyers seem like they are firmly wanting DUI death cases in this county, like in Fulton County, with all of those variables. And again, it can be a little bit counterintuitive. So you might also want to step back and say, and also let me look at some death cases in other places that maybe aren't quite as liberal traditionally as Fulton County to see what some of those awards have been. And you might be losing some multi-million-dollar cases if you don't do that. And on balance, there are many, many DUI defense verdicts, and people don't think about that. I was speaking to a group of judges a couple of years ago, and they were really surprised to hear that in DeKalb County, 24% of the verdicts that we had collected were defense verdicts, because DeKalb County's plaintiff's paradise, right? Not all the time. It depends on the case. There's a Gwinnett County verdict for $146,000. There was $146,000 in meds with a 4-level cervical fusion, clear liability rear ender, and the defendant was cited for DUI. So how did that case result in a defense verdict? Causation. They just didn't believe that that slight tap on the rear was sufficient to cause that, even though there were no prior meds showing that. Now, the immediate records after the injury showed degenerative disc disease, and I think the defense attorney did a good job of arguing that that didn't happen on the way to the ER too. So there are ways around that. So I don't want you to be lulled into a false sense of security just because you do have an egregious citation. On the other end of that, some of the most amazing soft tissue settlements I've ever seen have involved some of those egregious citations like DUI, hit and run, where there's some heat in the case, some potentially punitive elements. For years, we would see these $50,000 and $100,000 limits settlements in soft tissue cases that had under $5,000 in meds, and everybody at CaseMetrix is really shocked. And I said, no, we're starting to see this with some degree of regularity. The other day, as I was preparing for this, we got a settlement from Terrell County, Georgia. I could not find that on a map for you real quick if I had to right now. A settlement an insurance company voluntarily paid pre-suit for $496,000 on a DUI case with neck and back soft tissue injuries only. Now, of course, all these questions come up in our mind. How on earth is that? Because that is quite an outlier, paying $496,000 of the available $500,000. So I'm wondering, did the insurance company know something we didn't know because we were pre-suit and we weren't in discovery yet? You know, did this person have 4 prior DUIs? Or was that adjuster fired that afternoon after that happened? I mean, there are a lot of questions that come to mind, but the fact of the matter is those do happen. So even if you've got a DUI and it's a very minor injury and you're made a really good offer, if you're offered $40,000 on a $50,000 policy, you might be inclined to take it, but you might want to hold on to that and look at some real data before you do. There are all kinds of problems in cases, and those are the things we normally see. We normally don't see the world's perfect case. So if you do have cases involving things like questionable liability or prior related injuries, which we see a lot, and a lot of times plaintiffs are not forthcoming about that in those initial meetings, and then you get the medical records and they go, oh yeah, should I have told you that? Yeah, you should, that would be good. And so gaps in treatment, that's another thing too. I always tell plaintiffs' attorneys, listen to what the defense attorneys are telling you in conjunction with lowball offers. These are things that have worked for them in the past, and they put the fear of God in your client and in you. However, I like to look at real data because your average juror that's making decisions on these cases when they're tried, they're not insurance adjusters, they're not defense attorneys, they're not plaintiffs' attorneys, and they're not plaintiffs. So often things like this are seemingly ignored. So again, I like to look to the data to be able to educate opposing counsel about what juries have had to say, even in the presence of things like that. Another is conservative venues. I was visiting one of my insurance company clients one day, and I was setting up, getting ready to speak, and there was a big map on the wall, and it had a little cluster of counties in the middle, you know, Metro Atlanta, and they were all colored in red, and everything else was white. So I knew kind of what that story was, and of course I had to challenge it based on what the data has shown me. And so I said, hey, what's the deal with all these counties that are colored in red? And one of the adjusters said, oh, those are the bad ones. You got to watch out for those. I said, what do you mean? What's bad? She goes, oh, that's where all the big verdicts happen. So I start, you know, looking at some of the others. I'm like, what about Telfair County? Oh, no, you're fine there. I'm like, really? There's a $5 million case there last year. What about Decatur County down in Bainbridge, where everybody thought it was a fluke when a $40 million verdict came in there until a few months later there was a $150 million verdict that came in there. So it's not easy enough to say this county is liberal and this county is conservative. It still comes down to the case. But what data is showing me all over the southeastern United States is with the right case and the right evidence, the right facts, the right injuries, you can get big money virtually anywhere. And so you always need to be prepared to educate yourself first and foremost about where that case is pending, even as early as where you're deciding where you're going to file a case if you have multiple options on that. Another thing that we are called upon to do pretty frequently is to evaluate loss of life in an extremely old person or someone very young. And deaths of children are the worst cases. I'm a mother. I know a lot of you are parents. They're just about the worst things you can possibly read. Sometimes insurance companies will call us up and say, you know, we don't have any economic damages that we can look to. We don't have any earnings projections, any things like that. And 4-year-old, can you help us with that? And we'll take a look at them. On the opposite end of the spectrum, we see a lot of insurance companies that will make pretty low offers based on the advanced age of plaintiff's deceased. So you see death of a 91-year-old. I had a case like that, had been stuck at a $200,000 offer. They whipped out a mortality table. They made that offer. They sat at it. They had been sitting on that number for 6 months. And so one of the things we were asked to do is to show any verdicts or settlements in people ages 80 and up that were $1 million or more, and we were surprised at how many of them there were. So that number is not, the numerical age is not necessarily going to be a value driver up or down. Just look at the data and see what it actually says. One of the things I want to talk to you about before I sit down is responsibly using this data in conjunction with mediations. I don't think people are very successful when they just show up with at mediation with any surprises, whether it's a new surgical recommendation, a new injury, suddenly springing some settlement and verdict data on them. It's not fair. Defense attorneys spend a great deal of time evaluating cases any number of ways and working with the insurance companies to properly set those reserves so they are given what they both feel is an adequate amount of money to show up with, and hopefully we'll get the case settled that day within those reserves. So what should a plaintiff's attorney do? If you're going to use this data, get it into the hands of the adjuster or the defense attorney a week or two prior to mediation. It allows them time to consider that, because at the end of the day, you want them to show up with enough money because you want to get that case settled. If you're springing something on them at the last minute, you're not likely to get that done. Defense attorneys, there are great ways that you can do this as well. You might want to share some of that information with your own carriers to get more money in advance. But let's say you've got a case where you've got some really sound defenses. If you've got a motion for summary judgment pending, one of the scariest and smartest things I ever saw a defense attorney do one day at mediation is he came in and he had one of his exhibits was a bunch of verdict and settlement reports. They were cases that were similar to the case they had pending in summary judgment, that had all those cases had been tossed out in summary judgment or had resulted in a defense verdict. And they used that in conjunction with a very short opening statement. The defense attorney went on to say, "I'm waiting for this order in the mail. And I told my assistant today, if this thing comes in the mail and this is granted, it's game over. They're going to fax it over and we're going to go home." So they've set that stage all day long for this plaintiff to know, ooh, I could get nothing. So I think that gives them a better perspective as they're entertaining settlement offers during the day. I know it would get my attention if I were in the plaintiff's chair. If your case doesn't settle at mediation, as you know, we have a lot of great mediators in this state, and a lot of them do follow. I see some of them. Some of them will follow up with you in the week or two following mediation because they're not giving up. They still want to try help you get your case settled. And so if you haven't taken data with you, give it to them in the follow-up. You can give it to the mediators. You can give it to opposing counsel. Get that data out there circulating. That may be the one thing that makes the other side just step over. And defense attorneys, I think, don't want to make that call of shame. That's Roger Mills, one of our mediators down in Macon, would always call it that. It's not a good feeling, and I've been on the defense team, when you run out of authority at mediation and you don't get it done, and you do not want to call the insurance company, and you do not want to be sitting there with your insurance rep with your face red and going, we just couldn't get it done with this. It's quite a different story to frame it and saying, hey, look, I'm looking out for your interest now that I'm seeing all these big verdicts there. I think if we put another 50, 100 grand on it, we might be able to get it resolved. Let's give it a shot now that we know about this. Again, framing it entirely differently. After depositions, defense attorneys have to write letters to the insurance companies to talk about how that deposition went. So if you're sitting on some data, that's a good time to get it into their hands because you want that data to make it into the report. So what we're seeing is that plaintiff and defense attorneys actually use the data quite similarly. Everybody's interested in the highest numbers. A typical defense lawyer that calls us up and needs something quickly, they want to see the top 5 or whatever. Give me your top 5 wrongful death cases in DeKalb County. Give me your top 5 broken leg cases in Gwinnett. So what are they doing? They're not doing that to make sure they're going to pay you lots and lots of money on your case. They're making sure that they are assessing the risk. A lot of plaintiffs' attorneys will say, I think I got a good offer on the table, but I want to make sure. Show me what typically happens, but I've got a client who thinks she's going to retire at the end of this thing, and she's not going to do it, and she's got a lot of problems. Send me 20 or 30 defense verdicts. So everybody's trying to, it's like the lawyers are working as mediators. They're trying to get the parties to walk to the middle until it hurts, just like we're experiencing when we're at mediation. But just remember not to look at outliers. I think it's very important to look at what usually happens. And one of the issues I had with the national verdict reporters that I used to use when I was a paralegal, I did a lot of med mal, and I would get these crazy requests, and I didn't quite know how to talk to my client. They would say, I want you to do some jury verdict research on all the descending basilar artery aneurysm cases that have ruptured in the ER in Dodge County, Georgia. Yeah, I'll get right on that. Because I knew I wasn't going to find anything on point. And so I think it's really important to kind of step back, look at real data, and not look at just those outliers, not just look at the weird ones, not just look at the defense verdicts, but our largest layer of information in between are settlements. What happens 95% of the time, and the reasonable numbers that are in there. So you can look at things like all the variables that we've been talking about, not just simplifying it. I had a lawyer come up to me at a cocktail party recently, and he'd been kind of a naysayer about using data. He's an older insurance defense attorney who I actually admire a lot. And he came over, it was like he was sort of embarrassed, and he whispered, he goes, what's a broken ankle worth over in DeKalb these days? And I just said, it's not that easy. And I asked him about 6 questions rapid fire to talk about a lot of particulars surrounding that case. And so I think that's probably a good way to use it. Defense attorneys know one thing, and that is what they've been accepting in offers. Defense attorneys know what they've been paying. So when lawyers say, I know what my cases are worth, that's what they know, what they've been accepting or what they've been paying. I always encourage people, don't guess about the value of your client's case when there's data sitting there that you can look at. It's usually 3 or 4 mouse clicks, and most people pass the cost to their clients anyway. So from a business perspective, you always want to make sure that you're not only shortchanging your client, you want to make sure as a defense attorney that you're not the guy who's overpaying, because some people are, and we know who they are by the data. You want to hold on to the insurance clients that you've got. You don't want to lose them, because at the end of the year, they're looking at your ratios and your firm's been paying more than anybody else. If anybody's ever worked in an insurance defense firm where a carrier shows up with hand carts, they take away 300 files in one day and they give them to somebody else, because at the end of the day, they were settling for 1.8 times meds and you were at 2.3. It's cold world, and it happens. So I do think it's important to look at that, to hold on to your clients. Thank you for your time. And if anybody has any questions, do we have time for questions, or am I over? 1 or 2? I think we're good. All right. Thank you.